Then the third condition is that a person who fails to aver and prove that he was ready and willing to perform his part of the contract. A person who fails to aver and prove that he was ready and willing to perform his part of the contract. You must have seen that in every agreement for sale, there will be in the plain there will be a condition that plaintiff was ready and willing to perform his part of the contract, and he continues to be ready and willing to perform his part of the contract. If you fail to make such an averment in the pleading, and if you fail to establish it through evidence, you are not entitled to get a degree of specific performance. So these are the conditions. Third condition, I will tell you one or two important aspects are also there. Have you understood the aspect of aver and prove? You should not only make a specific pleading in the plaint that you were ready and willing to perform your part of the contract, you are ready to continue and perform the contract, and you will always be ready and willing to perform your part of the contract. These three aspects should also all be there. And what happens? If you fail to aver this, or even you make you an averment but you fail to prove it, then you are not entitled to get a degree of specific performance. It is subject to two clarifications. The first clarification is that suppose under a contract, the person making a claim is liable to make some payment. Question is, should he deposit the money in the court to show that he is ready and willing to perform his part of the contract? Typical example is that in a suit for agreement for purchase of property, plaintiff has to make payment and purchase the property. He has given an advance. Then he says in the plaint that I am bound to pay the remaining balance amount. I am ready and willing to perform my part of the contract. I was always ready and willing to perform my part of the contract. Grant me a degree. Since he is under a legal obligation to pay the remaining balance amount, to show that you are ready and willing to perform your part of the contract, is it mandatory on your side to deposit the money into court and to show your bona fides? Is it mandatory? Where do you get that from? No. Clause C of section 16 says, if there is an obligation to deposit money in court, it is not required to be deposited unless the court directs you to deposit. That's why, not by precedent. So that section 16C clearly says that if the plaintiff is under an obligation to pay money, just to show that he is ready and willing to perform the contract, he is not bound to deposit the money in court to show his bona fides. That's a clear provision in section 16C. Until directed by the court, unless directed by the court. Can anybody tell me a corresponding provision under any other statute which you must have studied or you must have conducted in a court of law? You know the provision under the Rent Control Act, the provision for reconstruction. In a suit for eviction on ground of reconstruction under the Rent Control Act, you should show that you have got the financial ability to reconstruct, and to show that you have got the financial ability to reconstruct the building, is it mandatory that you should deposit the money before the court and show that I have got the bona fides? No. There is one decision of the Kerala High Court which said that landlord is not expected to jingle the coins before the court to show that he has got the capacity. I have heard. To show that you have got the financial capacity. You need only have the ability to raise the funds. That's why the Supreme Court, Kerala High Court said, landlord, to establish that he has got the financial capacity to reconstruct the building, need not jingle the coins before the court. Just like that, in a suit for specific performance of an agreement relating wherein there is an obligation on the plaintiff to pay the money to establish that he was ready and willing to perform his part of the contract. He need not deposit the money in court. So there is a specific provision. 16C subclause 1. Then secondly, it specifically says that the plaintiff should specifically aver that he has got the capacity, he is ready and willing to perform his part of the contract. These are the two conditions. So the three situations wherein a person is not entitled to get a degree of specific performance I have mentioned. The first is that a person who, if he is not entitled to get a compensation, he is not entitled for specific performance. Secondly, a person who has become incapable of performance, not entitled to get specific performance. Thirdly, a person who fails to aver and prove that he has got he was ready and willing to perform his part of the contract. This was the original provision prior to 2018. Now I will tell you how it has been amended by the 2018 Act. The first clause again substituted by same provision relating to substitute performance, or section 16 subclause 1, which was originally available. That we said that a person who is not entitled to recover the compensation, is not entitled for specific performance, has now been modified and said that a person who got the substitute performance is not entitled to get specific performance. The second clause remains the same. The third clause, a change has come. It says that a person who fails to prove that he is ready and willing to perform his part of the contract is not entitled to get a degree of specific performance. Have you noted the difference? What is the difference in the new one? Originally the provision was that a person who fails to aver and prove that he was ready and willing to perform his part of the contract is not entitled for a degree. Now it says a plaintiff who fails to prove that he was ready and willing to perform his part of the contract is not entitled for the degree. What does it mean? What does it mean? You need not aver. You need not make an averment that you are ready and willing to perform your part of the contract. You need only prove in a court of law. Then it goes back to the question, does it stand to reason? Is it not against the basic principle of pleadings, which says that whatever you have to establish and within your knowledge you have to plead? I do not know why the statute was amended like that and said this averment part has been taken away and said that you need only prove. Without making an averment that you are ready and willing to perform is part of the contract, without specific pleadings to establish that these are the facts which show that I was ready and willing to perform the contract, how can the other person rebut it? Strangely, the amendment says you need not make an averment, but you need only prove it. That means it permits a proof without an averment. Strange amendment. To that extent you have noted when you have, after having gone through section 10, section 14 and section 16. I'll tell you the next section, then come back to that. I told you that originally provision was that section 10 and section 14 said that the power given to a court under the specific relief act for specific performance of an agreement was completely discretionary. That means even if it is satisfied that the plaintiff has established this case, for some other reason the court could refuse to grant benefit, being a discretionary relief. It could refuse to grant the relief. Since it has become mandatory to grant the relief now, section 20 has been amended. Section 20 dealt with the discretionary power of court. Section 20 prior to 2018 amendment said that granting of a decree under the specific performance was discretionary. Merely because it is discretionary, or merely the courts were not bound to grant a decree of specific performance merely because it was lawful to grant a decree. Section 20 said granting of a discretionary relief should be based on sound legal principles capable of judicial scrutiny, capable of correction by a court of appeal. This is the wording used in section 20. Section 20 says, granting of relief under the Specific Relief Act, specific performance of contract is discretionary. Merely because court shall not grant a decree merely because it is lawful to grant a decree. Granting of a decree or refusal to grant a decree shall be based on sound legal principles and capable of correction by court of appeal. What does it mean? It means that even if the court finds that there is no legal embargo in granting a decree, courts are not bound to grant decree. But whether decree should be granted or not, or whether decree should be refused, should be based on sound legal principles. Suppose the court says that, of course, the plaintiff has proved his case. He has proved that there was a contract, there was a breach of the contract, but I am not granting the decree because I think he is not entitled to. Is it based on a sound legal principle? The court has to give reasons. Court should say that these are the reasons, or in other words, it should not be merely based on the subjective satisfaction of the court. Merely court feels that the plaintiff doesn't look good, I am not granting him decree. Why the court is granting decree of specific performance or why it is refused should be based on sound legal principle capable of correction by a court of appeal. What does it mean? Can anybody tell me? What does it mean? Capable of correction by a court of appeal. Suppose a discretionary relief is granted. That means assume that suit is dismissed or compensation alone is granted by saying that I am not exercising the discretionary relief in favor of the plaintiff. Whether it was based on sound legal principles, how can the court of appeal determine? The court of appeal, while deciding whether the court has correctly exercised the discretionary relief, how can it exercise? Only if reasons are given by the trial court. It's not. So that's why it says that the granting of discretionary relief should be based on sound legal principles. This person, though has established his case, came belatedly. His conduct was not good. Though he is substantially correct, he made false documents and produced it before the court. So I am refusing to grant discretionary relief. So these are the sound legal principles, sound reasons which the court should give to show that I am refusing to grant discretionary relief. Only then the court of appeal sitting in appeal can consider and decide whether it was based on a proper appreciation of the facts or whether the discretion was correctly exercised. That means while refusing to grant a discretionary relief, the court should give cogent reasons. Simple. And what has happened now? This section 20 has become redundant now in 2018. Why? Because in all other sections, the discretionary power given to the court in granting a decree has been taken away. Then there need not be a section as to how the discretion will be exercised. So section 20 has been completely modified and substituted with what? A new section, that is a new relief, that is substituted performance. I have told you what is meant by substituted performance. So what is the essential condition for invoking section 20? Issue notice, 30 days notice. In case of breach, an aggrieved person is entitled to seek substituted performance only after giving 30 days notice. This you should understand is a very valuable right given to the party. So ultimately, after studying section 10, 14, 16 and 20, we come to three definite aspects. One, the main thrust of 2018 amendment was that discretionary power given to the courts prior to 2018 has been completely taken away. Now granting of a decree has become almost mandatory, almost mandatory. If the facts are established, only if the contract is proved, breach is proved, and the entitlement is proved, then he is entitled to get a decree. There is no discretion now vested with the courts. Secondly, a new relief has been granted to the aggrieved person in the form of substitute performance under section 20 of the Specific Relief Act. These are the two substantial amendments brought in. Then I will tell you a few minor disputes, and now I will give you a few decisions which deals with the discretionary power of the Supreme Court. What is the nature of discretionary power given to the courts under the Specific Relief Act? The first decision is Rajesh Kumar versus Anand Kumar. Rajesh Kumar versus Anand Kumar. The citation is 2024 INSC. Rajesh Kumar versus Anand Kumar and others, 2024 INSC 444. How the discretionary power has to be exercised is dealt with in that decision. Now, I told you that after 2018, discretionary power is not there. Regarding this, there are two decisions which says that after 2018, granting of decree is no longer discretionary. There are two decisions. One is Santosh Amma versus D. Sarala. Santosh Amma versus D. Sarala, 2020, 19 volume, 2020-19, that is the volume number, 19, SCC, page 80. 80. It says that after 2018, granting of discretionary relief is not a discretionary relief now, but at the same time it will be subject to section 11, 14 and 16, limited scope. Otherwise it is mandatory. Santosh Amma versus D. Sarala, 2020-19 SCC, page 80. This view there was later affirmed by the Supreme Court again in Sugar Singh, SUGHAR, Sugar Singh versus Hari Singh, HARI Singh, Hari Singh, 2021 SCC, 2021 SCC, online 975. Sugar Singh versus Hari Singh, 2021 SCC online SC 975. These are the two decisions which say that after 2018 the power is no longer a discretionary relief. Then I will ask you one thing. See, I have told you about 1963 position, or what was the position prior to 2018 and after 2018. What is the effect of this 2018 amendment? Is it retrospective or prospective? That came into force on 1/10/2018. 1/10/2018 is the date on which the Act came into force. Is this the 2018 Act a retrospective one or a prospective one? Supreme Court has said that the Act is only prospective. The decision is K. Sujata Reddy, Katta Sujata Reddy, it is Katta, K-A-T-T-A, Katta Sujata Reddy versus Siddham Setti, SIDDAMSETTY, Siddham Setti Infra Projects Private Limited. Katta Sujata Reddy versus Siddham Setti Infra Projects Private Limited, 2023, 1 SEC, 2023, Volume 1 SEC, page 355. The purport of the decision was that 2018 statute is only prospective, so that it has no retrospective operation. Then why did you tell you about the position of prior to 2018? After 1/10/2018, the statute, old statute has gone. 2018 statute is in force. Then why did I spend so much time discussing about the prior 2018 position? Illa, there is no retrospective effect. It has no retrospective effect. Correct. In old cases, instituted before 1/10/2018, old 1/10/2018, old statute will apply. That's the reason why I have been discussing. Then, I think it's clear. So, all suits instituted prior to 1/10/2018 will be governed by 1963 Act prior to the modification, and all suits instituted after 1/10/2018 will be governed by the new statute. That's what you should understand. Then, I told you about the continuous readiness and willingness. There are three Supreme Court decisions, the latest one, which specifically says continuous readiness and willingness is mandatory to grant get a relief. That is, continuous readiness and willingness is a condition precedent to grant of discretionary relief. To grant relief of specific performance. Three decisions I will give you, all latest decisions. One is C.S. Venkatesh. C.S. Venkatesh versus A.S.C. Murthy. C.S. Venkatesh versus A.S.C. Murthy, 2020, 3 SEC 280. 2020, 3 SEC 280. The second decision is Shenbagam, Shenbagam, Shenbagam versus K.K. Ratnavel, K.K. Ratnavel, Rathinnavel, 2022, SEC Online, page 71. P. Ramana versus D. Manmadarao, 2024, 7 SEC 515. I also told you the provision regarding the averment and proof of readiness and willingness. I told you under section 16(1), 16(3), plaintiff has to aver and establish that he was ready and willing to perform his part of the contract. This readiness and willingness and the duty to make an averment regarding that under the old act was dealt with by the Supreme Court in 3-4 decisions. I will give you 4 decisions. In all the cases, it was said that you should make an averment, that you are ready and willing to perform your part of the contract. The first decision is N.P. Thirujnanaman, N.P. Thirujnanaman, Thirugnaman, Thirujnanaman versus Dr. R. Jagan Mohan Rao, Dr. R. Jagan Mohan Rao, 1995, 5 SEC 115. Second is a decision which I told you earlier, C.S. Venkatesh versus A.C. Murthy, I have told you. Then the next decision is Kalavadi versus Ragesh Kumar. Kalavadi versus Ragesh Kumar, AR 2018 SC 960. Kalavadi versus Ragesh Kumar, AIR 2018 SC 960. Last decision is Vijay Bharati versus Savitri 2018 11 SCC 761. 2018 11 SCC 761. In that there is one more important aspect. 761. 2018 11 SCC 761. In that case, there was one decision. In the defendant sold the property to another party pending the proceedings. The question came up whether the purchaser is entitled to take up the defense that he was not ready and willing to perform its part of the contract. Or when the plaintiff sells the property, can the successor of the plaintiff take up a defense? The plaintiff claim that he was ready and willing to perform his part of the contract. The court said even the successor in interest is entitled to raise the contention of readiness and willingness. Now one question will come. In several cases, the courts which were, the courts differ in their attitude. When the Supreme Court said the plaintiff is bound to plead and prove that he was ready and willing to perform the contract, the first thing that the municipal subjects may do, some judges may do, is that whether to find out whether there is exactly the same words. The plaintiff was ready and willing to perform his part of the contract. He is ready and willing to perform his part of the contract. He will always be ready and willing to perform the contract, whether these words are there in the plaint. If those words are not there, dismiss the suit. Have you understood? So the court matter came up before Supreme Court in at least 2-3 cases where is it mandatory that even though to make an averment that he was ready and willing to perform the contract is mandatory, should he use the exact words? If you fail to do that, or if facts are pleaded in the plaint which go to show that he was ready and willing to work, merely because the exact words that I was ready and willing to perform the contract was not used, can the suit be dismissed? Came up before the Supreme Court in 3 cases. The first decision is Sayyid Dastagir, whether a strict reproduction of the statutory words is essential. Sayyid Dastagir, SYED, Dastagir, DASTAGIR. Sayyid Dastagir versus T.R. Gopalakrishna. 1999, 6 SCC 337. Vishwanath Ghosh, Vishwanath, VISWANATH, Vishwanath Ghosh versus Govinda Ghosh. 2014, 1 SCC 605. The last decision is Vishwanath Ghosh versus Govinda Ghosh, 2014, 1 SCC 605. The last decision is Motilal Jain versus Ram Dasi Devi. Motilal Jain versus Ram Dasi Devi. AIR 2000 SC 2408. AIR 2000 SC 2408. In all these 3 decisions, the Supreme Court said that you want to repeat the decision? Motilal Jain versus Ramdasi Devi, AIR 2000 SC 2408. In all these 3 cases, Supreme Court said, though it is mandatory to plead and establish that the party was ready and willing to perform the part of the contract, it is not a mathematical formula to be reproduced in every case. That means merely if that you may not specifically say that I was ready and willing to perform my part of the contract. You may not clearly say, use the exact words. But if the pleadings are so clear that you are ready and willing to perform your part of the contract, is it obligatory? Can the court reject the suit on that ground. Court said it is not a mathematical formula to be reproduced as such. So that though it should be, pleading should be there, it need not be in the exact words. But at the same time, you should establish that you are ready and you are ready, you are pleading and proof that you are ready and willing to perform your part of the contract. Is it clear? Then I will also take you to one more point, then I will stop it. Have you heard of the term? Time is the essence of the contract. You must be using that. What is that? Time is the essence of the contract. What does it mean? Anybody who can tell me? That means, you know the point. I think almost everybody knows the point. That is, if a period is prescribed in the contract, if the contract is not performed within the stipulated time, can you say that there is a breach of contract? Or in other words, every contract will contain a time period, time limit within which the contract has to be performed. Whether that forms the crux of the contract or on the ground that it was not performed within that period, can you treat the contract as void or has become to an end, terminated? That depends on the question whether the parties intended that this period was the basic essence of the contract. Or in other words, did the parties impliedly or indirectly or directly intend that if the contract is not performed within the stipulated time, it will be forfeited, it will be brought to an end. Did the parties feel so? The normal concept is that in the case of contract relating to immovable property, time is not treated as the essence of the contract. Whereas in the case of a movable property, time is treated as the essence of the contract. This is the normal basic concept. That does not mean that invariably in every case of immovable property, time will be treated as essence of, will not be treated as essence of the contract and otherwise. There may be cases wherein even in the case of immovable property, sale of immovable property, the parties may treat it as the essence of the contract. I will tell you one example. Suppose there is a contract for sale of an immovable property. The seller says, I am selling the property is under a distress. My residential property is brought for sale by the bank. Sale is fixed in May. I need money, that's the reason why I am selling this property. So that you should make the payment before May. And they fix a time. What does it indicate? That indicates that the parties treated it as the essence of the contract, though it related to immovable property. Have you understood? So that whether the parties intended to treat it as the essence of the contract is the crux of that principle. Where did you get that from? From where? There's a statute given indication. Is there a section? Have anybody come across any section specifically, in fact, which says that in the case, time is the essence of the contract? There is no statutory provision. It came because of a decision of the Supreme Court in a constitutional bench decision known as Chand Rani versus Kamal Rani. Chand Rani versus Kamal Rani. 1993, 1 SCC page 519. It said that normally in India, time will be treated as the essence of the contract in the case of movable property and not in the case of immobile property. That's how you are following it. Then what happened was that in one decision, K.S. Vidya Vandanam versus Vairavan, K.S. Vidya Vandanam versus Vairavan, Vairavan, 3 SCC 1, 1997 3 SCC 1. Supreme Court said that this concept of time is not the essence of the contract in the case of immovable property was rendered by the Constitutional Bench of the Supreme Court in 1993, when escalation of prices of property happened only in big towns, not in villages or coastal areas. Now a time has come where in every part of the country there is an escalation of price due to passage of time. So that it is high time that we give a go-by to that principle of time. Is not the essence of the contract in case of immovable property. Supreme Court did not say go against the Constitutional Bench decision in Chandranani's case. Supreme Court said the concept needs a relook. Same view was expressed by another bench of the Supreme Court, 20A, 20B and 20C. I told you earlier that 2018 amendment was brought in the background of new economic policies. So when 2018 statute was introduced, it contained one schedule relating to infrastructure projects. Infrastructure projects means it is big constructions like road, buildings, electric constructions, railways, etc. Those are brought within that schedule of infrastructure projects. Specific provisions were made under section 20A and B, etc. relating to infrastructure project. One section is section 20A, which says that in relation to infrastructure projects, there is a restriction in granting injunction. Has anybody come across section 20A? Section 20A says that no court shall grant an injunction in matters relating to infrastructure project if it is like granting of injunction is likely to cause impediment in the infrastructure project. So no injunction. Am I correct in saying that section 20A says that there cannot be an injunction in relation to infrastructure project? Am I correct in saying, if I say that there cannot be an injunction against infrastructure project under section 20A, am I correct? No. You should not understand the section 20A says that there shall not be an injunction against infrastructure projects. It only says no injunction against an infrastructure project which has the propensity, which may cause impediment in the progress of, only in that. That means you cannot grant, a court cannot grant an injunction, you cannot seek an injunction which will stop the infrastructure project. Other injunction can be there. Suppose the injunction is you shall not terminate the service of an employee engaged by the contractor in rendering infrastructure project. There can be an injunction against withdrawal of the security money. Such injunction can be there. But if it is likely to affect the infrastructure project, it cannot be granted. That's all. Section 20B deals with constitution of special courts for the purpose of infrastructure suits. Section 20C deals with relates to a time limit in relation to all suits under the Specific Relief Act. It says that all suits shall be decided and disposed of within 12 months from the date of service of summons. And the court can grant an extension up to 6 months. That's all. So we come to the end of that session. Any doubt on any of the topics which we have covered? Any doubt? So thank you so much for giving me this opportunity. Thank you, President, for giving me this opportunity. Wonderful opportunity to be again in CHERTHALA.